Start. If the dismissing authority accepts the findings recorded against the delinquent officer and differs from some or all of those recorded in his favor and proceeds to specify the nature of the action proposed to be taken on its own conclusions, it would be necessary that the said conclusions should be briefly indicated in the notice, full stop. In this category of cases, the action proposed to be taken would be based not only on the findings recorded against the delinquent officer in the inquiry report, but also on the view of the dismissing authority that the other charges not held proved by the inquiring officer are, according to the dismissing authority, proved, full stop. In order to give the delinquent officer a reasonable opportunity to show cause under Article 311 within bracket 2, it is essential that the conclusions provisionally reached by the dismissing authority must, in such cases, be specified in the notice, full stop. But where the dismissing authority purports to proceed to issue notice against the delinquent officer after accepting the inquiry report, it cannot be said that it is essential that the dismissing authority must say that it has so accepted the report, full stop. But we do not think that the words used in Article 311 within bracket 2 justify the view that the failure to make such a statement amounts to contravention of Article 311 within bracket 2, full stop. In dealing with this point, we must bear in mind the fact that a copy of the inquiry report had been enclosed with the notice, and so, reading the notice in common sense manner, the respondent would not have found any difficulty in releasing that the action proposed to be taken against him proceeded on the basis that the appellants had accepted the conclusions of the inquiring officer in the entirety, full stop. These observations are clearly in tune with the observations in Bimal Kumar Pandit case quoted earlier and would be applicable at the first stage itself, full stop. The aforesaid passages clearly bring out the necessity of the authority which is to finally record an adverse finding to give a hearing to the delinquent officer, full stop. If the inquiry officer had given an adverse finding, as per Karunakar case, the first stage required an opportunity to be given to the employee to represent to the disciplinary authority, even when an earlier opportunity had been granted to them by the inquiry officer, full stop. It will not stand to reason that when the finding in favor of the delinquent officers is proposed to be overturned by the disciplinary authority, then no opportunity should be granted, full stop. The first stage of the inquiry is not completed till the disciplinary authority has recorded its findings, full stop. The principles of natural justice would demand that the authority which proposes to decide against the delinquent officer must give him a hearing, full stop. When the inquiring officer holds the charges to be proved, then that report has to be given to the delinquent officer who can make a representation before the disciplinary authority takes further action which may be prejudicial to the delinquent officer, full stop.